of practicing lawyers also do not know about the history of arbitration in India. So I'll take you back. So today's discussion is going to be in three limbs. Firstly, I'll be speaking about the history of arbitration. Secondly, I'll be speaking about the present. And thirdly, I'll be speaking on what is the way forward, in my view. So I'll begin with the history of arbitration. If you talk about arbitration globally, the concept is not very new. It's been going on for ages. And when we trace back, then we realize that since the biblical theory, since the Bible, time of Bible also, King Solomon, you all may have heard of a very interesting incident that King Solomon was there and how two ladies came to him and said, "This is my baby, I'm the mother." The other woman said, "I am the true mother of this baby." And then King Solomon eventually decided that I will cut this baby in two halves and then you both can take it. Then one of the mothers said, "No, no, no, I don't want the baby to be cut in two parts. You let her take the baby." So that's how he decided that who was the true mother. So what people say, international jurists also, they say that the methodology applied by King Solomon at that time is the same as we apply today in arbitration. So that is considered as the first case of arbitration in the world. If you look at, then I'll take you back to the Greek, as per Greek mythology and as per the practice prevailing in the ancient Greece. Philip II, who was the father of Alexander the Great, he also used to, there is a discussion about it in some of the books, that there was a dispute between two countries at that time for some island, and that was decided by 5 Spartan judges by arbitration. So arbitration it's mentioned in the history, and when we talk about, but today we are only confined to the Indian arbitration scenario. So let's discuss the history of Indian Arbitration Act and how it evolved with time. So if you look back, the first act of Arbitration Act was not the 1940 Act, which a lot of people think it was. The first act of arbitration in India was the 1889 Act, and that is when arbitration for the first time was introduced in India. The functioning of 1889 Act was not up to the mark. There were too many technicalities, and it was against the very ethos of arbitration, the purpose why arbitration was in fact founded, to make dispute resolution easy, to make it better, and to in fact make it a solution and quick disposal of justice. Therefore, later on when CPC came, Code of Civil Procedure, I think it was 1908 when it came into existence, second schedule of the CPC was completely dedicated to arbitration. And interestingly, the 1889 Act was not implemented on the whole country. In the whole British India, it was only limited, its application was limited only to 3 presidency states, namely Bombay, Calcutta, and Madras. When the second schedule of CPC came, even that could not serve the purpose, because arbitration needed something more exhaustive and a proper act which could deal with all the issues. Therefore, there was a need which was felt by the legislature at that time, and in 1940, an Arbitration Act came into existence, and that, as we recognize today, as a full-fledged proper act which was set up by the legislature at that time. The functioning of the 1940 Act was criticized at length. Unfortunately, there was no provision, there was no part in the 1940 Act which dealt with the foreign awards, due to which many philosophers in fact criticized the functioning of the 1940 Act. In fact, in one of the matters, one of the judges passed very adverse remarks regarding the functioning of the 1940 Act. The last 2 lines I remember in that judgment, that the way 1940 Act has been functioning, it has made lawyers laugh and legal philosophers weep. So it was a subject of much criticism from the judiciary. And thus, though it kept working, but one thing to be noted is that the 1940 Act, which came into existence, it repealed the erstwhile 1889 Act and the second schedule of the CPC, because 1940 Act was the proper codified law on arbitration. Thereafter, in the year 1991, when the economic liberalization took place, then there was a need felt by the government that, look, now there's going to be foreign investment and we need to attract foreign direct investment. And thus, it is pertinent that we provide a comfortable environment for dispute resolution. The reason why it was felt was because when a foreign investor wants to invest in a country, they need to know that in case a dispute arises, how it is going to be resolved. Because when somebody is willing to spend millions of dollars in a project, he needs to know, because disputes are inevitable and they presume that disputes will arise. And therefore, a dispute resolution clause is put in an agreement. So they want to know how the courts of that country, how the legislature of that country is in fact dealing with the disputes. And thus, it was important that our Arbitration Act was ready to meet with all those challenges and was, providing a comfortable environment to the investors so that they can comfortably invest and they are not unhappy with the functioning of the courts and law. That's why in 1995, the Act was formed, but though it got implemented and came into effect in 1996, and that is the Act which we follow today, that is the 1996 Act. So this is the brief history about the arbitration in India. And now I'll be discussing the present, the Act of 1996, which is prevalent even today. So let's talk about the functioning of 1996 Act. The 1996 Act, which came into existence after the repeal of 1940 Act, this had a very interesting part too, which was dedicated to the foreign awards. Like I told you that the 1940 Act did not have any provision to deal with the foreign awards and enforcement of foreign awards. Thus, the 1996 Act wasn't essentially, the first part was dedicated to the domestic arbitrations. What is a domestic arbitration? A domestic arbitration is an arbitration wherein both the parties are the nationals of the country. They both are based in India. That is a domestic arbitration. An international arbitration, on the other hand, is an arbitration in which there is a foreign element. So if one party is a foreign party, it becomes an international arbitration. So part 2 of the 1996 Act, it talks about enforcement of foreign awards. So if there is an arbitration which is seated outside India, or in which there are both the parties are not domestic parties, then it will be governed by part 2 and not by part 1. So just for your information. Now moving on and coming to the functioning of the 1996 Act. There were various judgments. I'll take you to the judicial pronouncements, whatever has happened, some major developments in the law. So I'll start with the judgment of Bhartiya International. So the very interesting issue was in respect of the applicability of part 1 to part 2. For instance, part 1 had certain provisions in the Arbitration Act which were applicable only on the domestic arbitrations and not on the international arbitrations, the foreign seated arbitrations, which are governed by part 2. So a dispute arose in one of the matters that whether part 1 will be applicable to part 2 or not. So there was a judgment of Bhartiya International, which was the first landmark judgment on arbitration, in which the court said that part 1 will be applicable to part 2, which means that if there is a foreign award, the courts under section 9 will have the power, the Indian courts will have the power to interfere with it. And that was criticized majorly across the globe. And due to this reason, because arbitration aims at looking less interference from the courts, and the idea of Arbitration Act is to minimize the judicial intervention so that it does not become like a litigation, because litigation is not so popular. And this reminds me of a very interesting quote by Justice Mr. Falius Nariman in one of the conferences, where he mentioned that the future of arbitration is bright because the future of litigation is not. So the technicalities in litigation, in my view, are the reasons why litigation is now not the first choice of dispute resolution. Now, I'll take you back before I proceed to 1996 Act. I need to, I think, highlight some basic features of arbitration, why it is better than litigation. So A lot of you have different questions, but in principle, the major reason why arbitration is preferred as a tool for settlement of disputes or as a dispute resolution mechanism over litigation and other dispute resolution mechanism is because arbitration provides it the basic principle of party autonomy. Now, what is party autonomy? So, our party autonomy is the heart and soul of arbitration worldwide. Party autonomy basically means that both the parties will be responsible for everything and they can decide how they want to be conducting their arbitration. They can decide the venue, they can decide the place, they can decide what is the procedure which is going to be adopted in the arbitration, whether there's going to be oral evidence or not, whether certain provisions will be arbitrable or not. So all of that, parties have the liberty and parties dictate the terms. So that is a beautiful thing because parties feel it is very convenient and party friendly. Because in courts, on the other hand, party has no role. A date is being given of 6 months and there's no surety whether or after 6 months the matter will be taken up or not. So parties in a way get frustrated because they feel that these are commercial matters and money will get stuck. So idea is to resolve disputes quickly so that we can get our money at the earliest. The other reason why arbitration is preferred as a dispute resolution mechanism is that it is not technical like litigation. You all would agree, I'm sure Zia would agree with me if I say that technicalities in litigation nowadays are a major problem. When you are filing a matter in the court of law, there are too many technicalities which you have to follow, and registry marks various objections, and it takes you quite a lot of time to in fact clear them. So there are different formats on XYZ, and then you need to file it in this format. This is the formatting. This is the dot page size that you have to use. This is the line spacing. This is the paragraph that you have to add. You have to comply with so many things because unless you clear all those defects, your matter will not get listed. So I say that sometimes, in fact, half of the battle is actually won when your matter is actually listed before the court, because and even if it is listed, then the other side will come and say they have not complied with X, they have not complied with Y. Some technicalities will be pointed out like jurisdiction, limitation, though jurisdiction and limitation are also there in arbitration. But I'm just saying that some technicalities that it is not in the proper provision, proper format has not been followed, they have not disclosed XYZ, things like that. When such objections are taken, these are technical objections which are not on merits. The courts sometimes dismiss the application on these grounds and not on merits. And that is why I say that arbitration is better because it is very, very flexible. If you read Section 19 of the Indian Arbitration Act 1996, it categorically states that the Code of Civil Procedure as well as the Indian Evidence Act, the strict rules of these acts will not be applicable to arbitration proceedings, meaning thereby that the strict procedure, the procedural laws will not be applicable in an arbitration proceedings, due to which I feel that arbitration is a preferred mechanism for dispute resolution as there are less technicalities. Now, moving on to the next aspect, why arbitration is better. So arbitration is better because it is quick, it's much quicker, it is very convenient, parties can do it as per their comfort. And the good thing is that when you are doing an arbitration, you get to say a lot. For instance, there's a time period of 1 year in which the arbitration is to be decided. After the 2015 amendments, a provision was introduced in the Arbitration Act of 1996. This provision was Section 29A, which says that any dispute of an arbitration must be resolved within 1 year. So imagine an act providing that your dispute will get resolved in 1 year. Whereas in litigation in courts, you don't know. Some people say that longevity is, and half of the battles, how it happens. Some cases are going on for decades. So nobody wants to take that chance, especially in commercial matters. And therefore they prefer arbitration as the first choice and they want to do arbitrations. Apart from that, the other interesting thing about arbitration is that if my dispute is to be resolved, because it is a private setup, I can do a hearing in a hotel, in a resort, in a conference room, conference hall, as per the convenience of the parties. And timings and all are also very flexible. I can keep a full day hearing from 10 to 6. That's the general norm. And once the pleadings are complete, then parties prefer keeping 4 dates blocked together. Like today, if there's an arbitration between me and Zia, we can decide with the arbitrator that, look, let's block September 10th to 15th for this matter. So we are blocking 5 days in our diary just for one arbitration. So imagine in those 5 days, we'll only be dealing with that matter, and we can do justice to that matter. Because in courts, what happens is that today I'm doing a matter, then the next date of 6 months, after 6 months, I forget the matter. Then again, I have to refresh my memory, recollect all of that. So these are few advantages of arbitration over litigation and other dispute resolution mechanism. And that's why I feel it has become quite popular. Now, moving on to the next interesting topic, which is the provisions of 1996 Act. So I'm going to give you a brief background as to how you should start an arbitration, because a lot of you may not know how the arbitration starts, etc. So I'm going to tell you that arbitration starts. It is a very simple way of being involved in an arbitration. Once you are entering into any agreement with the party, all you need to do is you need to incorporate an arbitration clause in an agreement, which is generally the dispute resolution clause. And in that clause, what all you need to write, you need to write that if at all a dispute is going to arise between the parties, we will be resolving it by way of an arbitration. And who will resolve it? An arbitrator will resolve it. Arbitrator is the judge who will be resolving the dispute. And you will say that the act which will be applicable will be Indian Arbitration Act. The language of the arbitration shall be English, and the place of arbitration shall be New Delhi. So this is how you word an arbitration clause, and you put it so that tomorrow if disputes arise and if you have any issues with the other party, what you need to do is you need to commence arbitration proceedings. So this is the first step, wherein you ensure that tomorrow if a dispute arises, we will go to arbitration and we will not go to the court. And how you draft an arbitration clause, you need to read section 7. Once you read that, it will tell you what is an arbitration clause and what is acceptable. Now, moving on, if you have an arbitration clause, assuming that me and Zia, we entered into an agreement and we had an arbitration clause in that agreement, and disputes arise, because they do, that's how it is. And if Zia approaches the court, civil court, for damages, then my remedy would be, I will say there is an arbitration clause. How can you go to the court? So all I need to do is I need to file an application under section 8, which says that reference of parties to arbitration. So if a court is entertaining any application from a party, and if the other side is able to show in the section 8 application that there is a valid arbitration clause, then the court has the power to refer these parties to arbitration. And the court will say, I'm not going to entertain this matter because this is arbitrable. So this is section 7 and section 8, which you have explained you. Now, assuming that this has to go forward and arbitration is to be invoked, then how do you invoke an arbitration? For invoking an arbitration, all you need to do is you need to send a notice invoking arbitration to the other side, wherein you'll be giving certain facts and you'll be giving the background, and you will show how disputes have arisen and what are your claims. Once you point that out in an arbitration notice, you send it to the other side, who will be the respondent, you'll be the claimant, and that person will then respond to your notice. Now, interestingly, the question which arises is that when does an arbitration commence? It's very simple. If somebody asks you, the answer is section 21. So the notice of invoking arbitration is sent under section 21, and section 21 says that once you send a notice for invoking arbitration and the date on which the other side receives it, that is the date on which the arbitration will set to be have commenced. So always remember, the commencement date of an arbitration will be when the other side receives your notice invoking arbitration under 21. I hope so far we are clear how arbitration starts. Step by step I am going. If you think I need to skip something, we'll have a question answer round for 15 minutes. So all of that you can ask me then. Now, once you send a notice invoking arbitration, the other side will obviously not agree with you and will dispute your claims. Then the only remedy for you is to get an arbitrator appointed. Now, who's the arbitrator? Like I told you, arbitrator is a judge who resolves the dispute between the parties, and he'll be the arbitrator for your case. For appointment of an arbitrator, you will file an application under Section 11 before the court, and you will request the court to appoint an arbitrator for you. Then the court, which is the High Court, will appoint an arbitrator. So High Court is the concerned court for appointment of arbitrator in all domestic arbitrations, and Supreme Court is the concerned court for appointment of arbitrator in any international arbitration. Always remember that. The district courts will never have the jurisdiction to appoint an arbitrator. Many times lawyers inadvertently file the applications before district courts. District courts will never have the authority to appoint an arbitrator. As per the Act, only the High Court is the concerned court for domestic arbitrations and Supreme Court for international arbitrations. Now, moving forward, I will like to tell you that once you get the arbitrator appointed from the court, the next thing that happens is that arbitrator takes the charge and then requests the parties to file pleadings. You know what the pleadings are. Statement of claim will be filed by the claimant. Statement of defense will be filed by the respondent, and there will be a rejoinder by the claimant after that. There are times in an arbitration when you need some interim measures. Now, what are interim measures? Basically, any interim relief which you are seeking from the tribunal. Like in civil courts, you have Order 39, 1 and 2, where you ask for an injunction. Similarly, there may be interim reliefs which you may require from the tribunal. So there may be a situation that the arbitrator has not been appointed and you have not invoked the arbitration. Still, you need certain relief. And in that case, you will file an application under Section 9, which talks about interim reliefs by the court. Why will you approach the court? You're going to the court because there is no arbitration tribunal. Because if there is an arbitration tribunal, then the concerned provision is Section 17 for filing any interim relief application before the tribunal. So the law is that if there is a tribunal, you go under Section 17 for any interim relief, because the tribunal, after the 2015 amendment, has all powers of the court. And similarly, if the tribunal is not in place and you want an interim relief, some injunction, some stay on bank guarantees, etc., then you file a Section 9 application, and there may be circumstances when the tribunal is in place, but the remedy which you are seeking cannot be granted by the tribunal. For instance, in case of third party, if you are seeking a third party relief, the tribunal will not have jurisdiction over third party. So you will have to file a Section 9 because the court can grant you relief against a third party and arbitrator cannot do that. So Section 9 can also be filed in such cases. So this is the distinction between Section 9 and 17, which in my view are very important provisions, because you need to know 11, 9, these are very important. Now, assuming that you have an issue with the jurisdiction of the tribunal, then in that case, you will file an application under Section 16, wherein you will say that the tribunal does not have the jurisdiction to hear these matters because there is no valid arbitration agreement between the parties. So this is Section 16 application. And interestingly, Section 16 is based on the principle of competence, which means that an arbitrator is competent to rule on its own jurisdiction. So 16 is the relevant provision. And assuming that the arbitrator says that, no, I have the jurisdiction, then you cannot file an appeal against it because it is not an appealable order. You will have to wait for the arbitrator to pass the award, and then you can only challenge it as the part of the final award under Section 34. Another aspect, another important provision which I think I would like to highlight is that when an award is passed by the arbitrator, the party which is willing to challenge that award, the only recourse, the only remedy against an arbitral award is Section 34. Now, what is Section 34? Section 34 basically gives certain grounds on which an arbitrator's award can be challenged by the party, and the grounds are very limited. It's not like regular suit that you can challenge, file appeal against it. The scope is very, very, very narrow, and there are very limited points on which you can challenge an award. There have been judgments of the court, including the judgment in Associate Builders, and there's another judgment, SsangYong Engineering, by Justice Nariman, wherein the courts have clarified that while dealing with the 34 application, the courts are to refrain them to certain aspects, including, so there was an amendment of 2015, wherein it was defined and the scope was further narrowed down that if an award is against the public policy, only then and only then the courts will interfere. The courts cannot interfere with an arbitral award on the ground that they feel that, that arbitrator followed a particular view and he should have not followed that view, he should have followed the other view by looking at an evidence or anything. So, on these grounds, awards cannot be interfered. Award can only be interfered if there is fraud or corruption involved, or the award is against the basic ethos of justice and morality, or if it is against the fundamental policy of the Indian law. So, something which shocks the conscience of the court. So these are the very narrow grounds on which an award can be set aside. The reason, like I said again, is to promote arbitration and to make it faster. That's why if a court is dealing with a matter under Section 34, it cannot reappreciate evidence because arbitrator is the best judge of evidence. That's the principle that is followed. Now, moving on to the appeal. So after you file a 34 and assuming that you lose 34, the next recourse which is available to you is Section 37. Now, Section 37 is that provision in the Arbitration Act which talks about appeals which are lying against certain orders. Under the Arbitration Act, if you read the language of Section 37, the very first line says, an appeal shall lie from the following orders and no others. That means if you want to see whether a particular order of a tribunal or of the court is appealable under the Act, you only have to look at Section 37. And once you see Section 37, you will find out, okay, yes, this is appealable and this is not. So if it is not appealable under 37, you cannot appeal it. That's something which you must bear in mind. So we have discussed the most important relevant provisions of the Arbitration Act. One which I missed is Section 36, which talks about enforcement of a domestic award. So once you win the award, you need to now get the award executed like a decree of the court, and it is executed as if it is a decree of the court. That is what the language of 36 suggests. And because of this reason, the courts sometimes direct the parties, the losing party, to in fact deposit the amount which it has lost with the court so that the other party gets some money in the hand. Now, this is the long and short of the 1996 Act. Now, I will move on to certain amendments which were made in the 2015. So, the major problem with the Arbitration Act of 1996 was regarding the automatic stay. So, the practice was that the moment you get an award in your favor, so suppose I won the arbitration award, and Zia is not happy with the award because it is against him. Now, Zia will file a Section 34 in the court. And the moment he files a 34, there will be an automatic stay on the operation of the award, which means that I will not be able to execute the award in the court of law. And the 34 would go on for years and my money will be stuck because I can't get it executed. And there's an automatic stay. Therefore, on 23rd October 2015, when the amendments came, the major development was the court said that there'll be no automatic stay. What will be the practice? If you're filing a 34, you file a separate application under 36(2) for stay of the award. And the court will stay the award only after certain conditions have been met by you. Now, the conditions that the court imposed court will tell you, the practice which I have seen generally in Delhi High Court, is that the court will say you deposit 50% or 75% of the amount, and only then you will get a stay on the operation of the award. So that amount has to be deposited so as to make it friendly with the person who has won the award. Should actually get some money, and he should not be deprived of the fruits of the award. He should actually get something. So it is in line with that, this practice. But the major controversy which arose because of this amendment was whether this amendment will apply to pending proceedings or not. Because as on 23rd October 2015, many 34 applications were pending, which were going as per the old law, that there will be an automatic stay. Now, whether an application was to be filed in those matters under 36(2) or not for stay, or whether there will be an automatic stay because they are pending matters. So it took 3 years for the court to decide it. Justice Nariman passed the judgment in BCCI versus Kochi Cricket Association. It's a landmark judgment. You all must read it. Very important judgment. What Justice Nariman said that because it is a procedural amendment, 36(2) will be applicable even to pending arbitration proceedings. So that was the long and short, some 105-page judgment almost. And I think you would not want to go through the whole judgment. So the gist is that what Justice Nariman said, that only 36(2) of the Arbitration Amendment Act of 2015 will be applicable retrospectively, which is the pending proceedings which were in the court. Now, moving on to the next discussion, there's another judgment. Now, what happened after this? When Justice Nariman passed this judgment, there was, in fact, another amendment which was being suggested by the Law Ministry, which is Section 87 of the 2019 amendments. Because after the 2015 amendments, the Arbitration Act got amended in 2019. So there was a discussion regarding this, and there was a Section 87 which was introduced by the Law Ministry, by the legislature, as per which the whole amendment of 2015 was prospective, including the 36(2). So in a way, this was in conflict with Justice Nariman's judgment of BCCI, which said that 36(2) will be applicable retrospectively. But the Section 87 of the 2019 amendment said, no, the whole Arbitration Act of 2015 Amendment Act will be prospective and not retrospective. Since this was, there was a discussion that it will be notified, there was a challenge to Section 87 in the Supreme Court, and there was another judgment passed in Hindustan Construction Company, wherein Justice Nariman again struck down the Section 87 of the Amendment Act of 2019 and said that it is against the ethos of the Arbitration Act of 1996. And he said this would in fact put arbitration on a back burner and it's a regressive approach which has been adopted. So he said, no, there'll be no automatic stay, even in the pending arbitrations, which were pending prior to the 2015 amendment came into existence. So currently the law is that 36(2) will be applied even on pending proceedings. And if there was an arbitration petition filed in the court under 34 before the amendment of 2015, and it was pending on that date, then it will be governed by the new Act of 2015. So this is the long and short of it. I know it's slightly confusing, but you need to read the BCCI judgment and the Hindustan Construction Company judgment. Both of them are landmark judgments. This will help you in understanding what is the discussion and why, how the law is as it stands today. Now I'll take you to another interesting issue in arbitration that was there for years, which was regarding unilateral appointment of arbitrators. So the practice was that people used to appoint arbitrators. So if I and Zia had an arbitration clause, what the practice was earlier, that Zia would retain the power to appoint an arbitrator. So either he would appoint somebody from his company, his managing director, as the arbitrator, and this was a norm which was adopted. Now to overcome this issue, something very interesting came up. After the 2015 amendment, there was a Schedule 5 and Schedule 7, as per which the legislature made it clear that anybody who has an interest in the subject matter cannot be appointed as an arbitrator. and a disclosure has to be given by the arbitrator about any circumstances which will give rise to his independence or impartiality, justifiable doubts as to his impartiality, like his relationship with the lawyer, or whether he has been appointed earlier or not. All these things he will have to clarify in that disclosure. This being the case, the issue that arose is a judgment came in TRF Energo in 2017, if I'm not wrong. TRF said that if you become ineligible to be appointed as an arbitrator, then you cannot appoint another arbitrator. Now, very recently, in one of the judgments of Justice Yuju Lalit and Justice Indu Malhotra, which is Perkins Eastman. Read this judgment if you get time. Perkins Eastman versus HSCC. In this case, the courts have clarified and put an end to a long controversy that if a person has interest in the subject matter of the dispute, he must not appoint the sole arbitrator, which means that one party can now not appoint an arbitrator unilaterally. So if I and Zia are in a dispute, I cannot appoint the arbitrator. The arbitrator has to be a neutral person. Because earlier what used to happen, people would appoint their favorites as the arbitrator and used to get favorable awards easily. So that would defeat the very purpose of arbitration. And that is why this judgment is a very positive and a very progressive approach in the arbitration profession. So now coming to the other issue which was settled regarding seat and venue. This is the last topic which I am touching today, because I think if you look back in arbitration history, these three major issues have always been the topic of discussion regarding the retrospective applicability of 2015, which I've explained you in BCCI versus Kochi Cricket and Hindustan Construction Company. Then the other issue was of unilateral appointment. I've told you two landmark judgments, TRF Energo and Perkins Eastman. Now, third issue is regarding seat and venue. What is the seat? What is the venue? I'll just clarify quickly. So seat has nowhere been defined in the Arbitration Act of 1996. Venue as such is only a convenient place where parties can meet. Venue can be Delhi International Arbitration Center. It can be Taj Mansingh. It can be any place where you want to do your arbitration. The significance of a seat of arbitration is this, that once there is a seat defined, like for instance, if I am entering into an agreement with a foreign party and the seat of arbitration is Delhi, then Delhi courts will have jurisdiction to deal with all matters pertaining to that arbitration. So seat is very important. It is very significant. The seat of arbitration is the epicenter of an arbitration, and it determines the jurisdiction of that court and gives exclusive jurisdiction to those courts where the seat is located. The judgment in Hardy Exploration case was a judgment which said that if the seat has not been defined in the Arbitration Act, then how do you know where and which court will have jurisdiction? Because sometimes parties draft their arbitration clause poorly, due to which it leads to a lot of controversy. So the court said that, look, if the place is defined, then you will simply determine it. If place plus certain other factors, concomitant factors are present, then that place can be treated as the seat of arbitration. So if I said that place will be Delhi, then Delhi plus certain other factors like cause of action arose in Delhi, parties are situated in Delhi. These can be other concomitant factors which can make the place the seat of arbitration, though place and seat are not the same. But it can be treated in certain exceptional circumstances. This is what Hardy Exploration case said. Now the approach of Hardy was challenged in a later judgment, a very recent judgment of I think 13 December or 5th December 2019, which is the most important landmark judgment today and the most controversial. It is BGS SGS Soma, in which the question was the same, whether a place can be determined as a seat of arbitration if the seat has not been specifically mentioned. Now the answer to this was given by Justice Nariman in this judgment, wherein he said that, look, place or venue, these terms have been used in an arbitration clause, and if there is no seat specified, then they will be treated as the seat of arbitration unless there is anything significant contrary to the same. So unless there is something which is showing contrary, that look, place cannot be treated as the seat, then in the absence of such significant thing which suggests otherwise, the place in normal circumstances will be treated as a seat of arbitration. What Justice Nariman also said, Justice Nariman said that look, the judgment in Hardy Exploration case and Devas judgment of Delhi High Court Division Bench, they are incorrect in law because they rely on a judgment of 5-judge bench in Balco and do not apply Balco correctly. The interesting part about this judgment is that both Hardy Exploration case and BGS SGS Soma are 3-judge bench judgment. So it is not possible for a 3-judge bench to say that another 3-judge bench is wrong because they are equivalent benches. So equivalent benches cannot comment on this, but it is interesting to see how the law will be settled. So I think now the law will have to be settled by a larger bench, by a 5-judge bench judgment. So we'll have to see how it turns around. But it is very interesting, and this is how it is, the present law. Now coming lastly to the future of arbitration, I think that the 2019 amendments, some of the provisions have not been notified. The 2019 amendment has proposed which Arbitration Council of India, which will be grading the institutions and which will be grading the arbitrators, and that will play a very, very important role in shaping up the future of arbitration. The focus of the 2019 arbitration is making India a hub of arbitration, making it globally a super hit destination for arbitration so that more and more investment comes in. And the other reason is that they want to make it more, user friendly, investor friendly, and they want to give ease of convenience to the investors. And they because the current scenario is that 80-90% of the arbitrations in India are domestic arbitrations, ad hoc arbitrations, not domestic arbitrations. Ad hoc means that parties make all arrangements themselves, and it is very flexible, but it's not organized. So therefore, preference is given to institutional arbitration because an institution like Delhi International Arbitration Center, Mumbai Center for International Arbitration, ICC, SIAC, these institutes play a very important role because they make it very smooth and very comfortable and convenient. So institutional arbitration are always preferred. And that's why India wants to institutionalize arbitrations and make it more organized. So that is the reason why 2019 amendment came into existence. One important aspect about 2019 amendment is that now they have defined a certain qualification criteria for an arbitrator. Schedule 8 has been introduced under the 2019 amendment. So it will be interesting to see how it turns up. But now in the virtual world, how it's going to be very interesting because now hearings are taking place virtually. I'm doing arbitrations on video conferencing. So it will be very interesting to see how things shape up because none of us was prepared for this. And it's like, it came like a surprise to all of us. We were not virtually equipped. We were not ready for this. But now that it has happened, it has happened. It is what it is. And we are going to stick to it. We'll just see how things shape up and how COVID impacts arbitration in the longer run. So with this, I'd like to conclude the discussion for the day. We can have question answers now. We have 15 minutes and I think I finished in time. So any of you, if you have any queries, I'll be more than happy. If somebody wants to speak, Zia can unmute you. Yes. It would be better if you ask me like that because when you type questions, sometimes you're not able to explain yourself clearly.
Exactly. Anybody who want to ask any question may raise the hand. I will unmute that person. You may directly raise the hand. By then, sir, I want to ask one question. How you will advise all these students who are just into the final year of the law or they have just passed out the law as a career in arbitration? What is the career perspectives this can explore in the field of arbitration? How they can start their own personal arbitration? I'm unmuting you, sir. I'm unmuting you.
Yeah, that's okay. I thought that you're going to mute me because people are tired of listening to me. Okay. So the question is, you were saying that how somebody should pursue a career in arbitration. Is that the question, Zia? Can you repeat it? I'm sorry, I was not very clear.
Yes, sir. Yes, sir. This is the question which I asked.
Okay. But most of your participants, are they students or they are Professionals, accordingly, I'll answer.
So few are final year of the law students, we have professionals also, law pass out also. It's a mix.
Okay. So for law students, I would say that, I mean, for everybody, this is not just for law students. The idea is to stay updated. You need to read judgments. Like the thing that I do is I'm only reading judgments day and night. So any judgment which is passed by any court in the country on arbitration, I've developed this habit with time that I read it the very same day. So this helps you keep updated, and you should also start writing articles, pick up interesting topic, give your views on it, so that you can actually read and research more and get insights about the profession. Because the idea is that once you are into it, you make it your passion, you just want to know more and more and more, read more and more and more. So the more you read, the better it is. And once you have that knowledge, and whenever you apply for a job in an interview, if they ask you if you are able to tell them everything with citations and history of arbitration and interesting judgments, then that helps. For students, I would say that any firm which is dealing with arbitration day and night, the idea is to do internships or training program with them, so that you realize or understand how arbitration works and how this fraternity is. And attend conferences which are happening in the city. Almost every month there used to be conferences, and now recently there have been so many webinars also. You can see all those webinars which are on YouTube, so you will learn a lot on arbitration, and eventually this would help you in understanding the subject. And once you know the subject, I don't think there should be any problem in pursuing a career in it, whether you go for an interview or you apply for your masters. And the idea is to write more and more, write articles, encourage yourself. Yeah, that's what I think is the right way to go forward.
So we have a question from Vipul. Vipul, I'm unmuting you. Directly ask the question. Vipul,
Thank you, sir. Sir, my name is Vipul Kumar, and my question is that in this pandemic situation, hello,
Yeah, I can hear you, Vipul.
hello.
Vipul, I can hear you.
Yes, sir. Sir, in this pandemic situation, how? Yes, sir. In this pandemic situation, how arbitration proceeding can vital role? Just enlighten me that in this situation.
Okay, you want to know how arbitration will be, in fact, encouraged during these unprecedented times. Good question. So basically now what's happening is everything is becoming virtual. And since arbitration, like I said, is very flexible, unlike the courts, it all has to be as per the convenience of the parties. So like assuming that this was an arbitration proceeding going on right now, I will just be carrying the files with me and I can show it to the tribunal. Zia may be the arbitrator, you may be the other side. So, we can have it very conveniently. The only issues which will be faced in arbitration is when the matter is very voluminous and a cross-examination has to be recorded. Because the beauty about cross-examination is that a lot of documents have to be read simultaneously. So sometimes it becomes problematic because there's a lot of confusion. When you're sitting in front, you can help the arbitrator. You can see the expression of the witness. But on a video call, you may not know all of that. Virtually, slightly, it will be difficult in those matters where the files are running into thousands of pages. You won't have the assistance of your juniors taking out the files for you, and for the arbitrator also to have his assistant. Otherwise, I think in these times, arbitration will be the first choice and will in fact get boosted and more promoted, because now people are very unaware about the court system and all, how virtual hearings are going to take place. So I think they will now choose it as a preferred method. So COVID, in my view, may give rise to more arbitration. Yeah.
Sir, one question is from Advocate Nimesh
Yeah.
Ansari. He's asking, what are the amendments which you suggest must be carried out in future in arbitration?
Excellent question, Mr. Dinesh. I had written an article on bar and bench. If you have time, you read it. Issues in appointment of, I had written a conflict in appointment of arbitrators, issues and suggestions. So I had given 3 suggestions. One of that I've seen in the judgment. I'm very happy. I wanted to get done away with the unilateral appointment of arbitrators. I thought that was a major issue, but that got resolved in the Perkins judgment after my article. The other 2 suggestions which I really want, one is confidentiality. So arbitration is confidential. Nobody gets to know what happened between 2 parties. because if an award is being passed, it is not published. So I think that if this practice is done away with, if confidentiality goes, and if the awards are being published online, it will serve a dual purpose. Firstly, that there'll be a format for people to know how to write an award. Many arbitrators don't know how to write an award because some of them are advocates. So they'll have good literature because some awards are very, very nicely written. A lot of law, and students and academicians will also benefit from it. They'll get to read judgments in arbitrations. Secondly, it will be more fair and more credible because people will be conscious about their image. They know the award is going to go in public and people will read what I am writing. So they will be more diligent and more careful. So I think that was one major suggestion. The second is that there is nothing in the act against the arbitrators. If an arbitrator is giving a frivolous disclosure, then there is nothing against the arbitrator. So something should have been there, some mechanism to find out, some database perhaps, wherein we could find about the history of arbitrator, how many arbitration he has done, whether he knows the party or not, things like that. So these are the two essential suggestions which I think I would prefer in arbitration. Yeah.
Another question is from Avnish Upadhyay. Avnish, you can ask the question. I'm unmuting you.
Yes, sir. Sir, my question is that what is another option for the party if he is not satisfied with the arbitrator award?
So
Another option, sir.
The only option with the party is to file a section 34, like I said, because under the act, that is the only recourse that you have once an award is passed. Unless during the arbitration you feel that, look, the arbitrator is not fair, he's biased, or any other reason, then you can file an application under section 1213, which talks about two grounds for challenging the arbitrator: if he's biased, or if he's impartial, or if he doesn't possess the qualifications parties agreed. Then in that case, you can always challenge. But after the award is out, the only recourse that you have is section 34, unfortunately, and nothing else.
So one question is from Simardeep. Simardeep, please ask the question.
Good afternoon, sir.
Simardeep.
Yeah.
Good afternoon, sir.
Good afternoon.
Sir, what is the major difference between Section 9 and Section 17 of the Act?
Yeah. So I told you after 2015 amendments, Section 9 is confined to before, during, or after the words that have been used. That before the arbitral tribunal is appointed, during the arbitration proceedings, or after. The major issue is that once the tribunal is there, though it has all powers of the court under 17, you can always file a section 17. But arbitrator is a creature of an agreement, and he cannot travel beyond the agreement, and he will not have any power on third parties. So there are certain remedies and certain reliefs which only the court under section 9 can grant, an arbitrator cannot. For instance, if it is a case of bank guarantee invocation and you want to restrain the bank from encashing it, so bank is not a signatory to the arbitration agreement, therefore arbitrator will have no power over him. Thus, a section 9 is a preferred method because the courts will have exercise power and directions on third parties. So that is one major difference between 9 and 17. That efficacious remedy which only 9 can give and not 17 under in respect of third parties.
Another question is from Anant Pathak. Anant Pathak, you can ask the question to sir.
Yes, sir. Thank you, sir. Thank you very much. And good afternoon, sir.
Good afternoon.
My name is Anant Pathak, sir. My question is what happens if a party defaults or disobeys an order made by the arbitrator? Can you say something?
Yeah, so after the 2015 amendments, the teeth have been given to the orders of the tribunal. And if you read the language of 17, for instance, it says that arbitrator shall have all powers of the court. So it is a clear contempt. It cannot happen. You cannot disobey the orders of the court. The award passed by the tribunal is treated as a decree of the court. Similarly, an order of the tribunal is passed as an order of the court. So it's exactly a contempt, just as it is an order of the court.
Sir, one question is from Archana Pandey. She's asking, sir, whether after deciding the arbitration method, one party can refuse to indulge in it. And if you do so, what is the remedy?
So once you have an arbitration clause, you cannot say, I don't want arbitration. There is no option left for you. There cannot be an alternate remedy unless both the parties are saying we don't want to go for arbitration. So if you have entered into an arbitration, you cannot get out of it later.
Another question is from Raya Lal. Raya Lal, please, you can ask the question directly from the sir. I have unmuted you.
Good evening, sir.
Good evening.
Form of ODR also, that is online ADR, right?
Yeah.
However, we don't have the Arbitration and Conciliation Act. So, do you think that the problems related to ODR, like does ADR Act, like the Arbitration and Conciliation Act, justify the problems which are faced in ODR? Because negotiation is not included in the Arbitration Act. However, it is a form of an ODR. And while the also the jurisdiction questions that may arise because of it, do you think that the ADR Act is capable enough to, or should we need a new legislation for the same in these
I
times
think
of pandemic when everything is going on?
you're absolutely right. I think there is a need for proper guidelines, whether in the form of an act. I don't know if an act is required, but I think that some guidelines are definitely required. Like many institutes have issued, ICC, SIAC. If you read, they have combined themselves, and there's a joint statement given by them that how filings are to be done, how matters are to be resolved online now. I think similar guidelines are required. But on the other hand, if you talk about the mechanism, I think Arbitration and Conciliation Act in itself is sufficient. However, I think currently in India, there is a need for a separate legislation for mediation. When you talked about ODR, I told you I don't think an act may be required because it's a very recent concept, and many few platforms have started something. Private platforms have started ODR facilities, though it has not gained recognition currently in the country. So I may not feel the need at this moment. However, I feel that mediation has a bright future, especially in these times, and mediation should have a separate legislation of its own, and then disputes can then be resolved by mediation. So yeah, that's my take on it.
Another question is this, sir. What we have seen that after 2019, we have come into a institutional arbitration. So how
Yes.
do you see the future of an individual arbitration? Do we end up with individual arbitration?
See, in matters where the stakes are small, stakes are not very high, they cannot afford the fees of the institution, in my view. So in my view, some ad hoc arbitrations will go on in a very small petty matters. But yes, but I still think, because 90% matters in India are ad hoc, they're not institutional. So I mean, I don't think it will be too easy to make in India convert it into an institutional arbitration hub. I think that will take years or perhaps decades, because India is used to ad hoc culture. So in my view, ad hoc futures still have a bright future.
Any other question, please?
Yeah, any last question we may have, because I think we have almost reached the time and I tried to respond to all the queries.
Okay, so we are done with the queries, and thank you very much, sir, for an enlightening
Thank you.
session. It was really an awesome and wonderful session to have you here at Zia Judicial Legal Research Cell. Hope you also enjoy this session with our participants.
Yes, I enjoyed it very much. And if anybody has any further questions, you can always reach out to me with your query. I'll be more than happy to address any query which perhaps you may have missed today.
Okay, sir. So we will share your email ID and we'll make you disturb through your email. So we will sharing your email ID with all our participants.
Generally, I get messages on my LinkedIn. So that's the best place to reach me.
Great. So one last question is there.
Yeah.
One person is asking, sir, what is the government job opportunity in the field of arbitration?
Okay, government job. I think there are many positions in the government also, not for arbitration specifically, but you can be a law officer in any of the government department, because the government departments are doing a lot of arbitrations nowadays. So I think it has, if you have knowledge of arbitration, it's an add-on. Plus, ministry also has certain jobs wherein you are making policies, etc. I think that is one area where you can consider going. Apart from that, in arbitration, I feel that you may consider, working as a teacher or an academician in any government institute. That can be a government opportunity. Plus, lastly, I feel that government opportunity can be in High Court, where you are working with some ASG or with some as a panel counsel, because a lot of councils are doing there are special councils for arbitration. Like DDA has its special counsel who's doing arbitration. So many PSUs also engage people for arbitration matters. So I think there are a lot of, but it may not be a permanent job, of course. Yeah.
Thank you very much, sir.
Thank you, Zia.
The session. Thank you, sir. Thank you.
It was my pleasure. Thank you, everyone. I hope you are all safe. just stay productive and keep learning.
Thank you.
Thank you very much.
Thank you, everybody. You all will get your certificates by tomorrow afternoon. And thank you very much for being participating with us. Keep participating and make us keep motivating us. Thank you very much. Hope this session was good. The video of the session will make you available through our YouTube channel after 2 days. So if anybody has missed any part of video, it can enjoy the video again, but after 2 days only, it will be available upon our YouTube channel, that is Zia Judicials. Thank you very much. Thank you.